Hello everybody and welcome to Law Bite number 125, dated December 6th, 2020. I'm Walter, your mobile historian and blue-collar scholar. This Law Bite is entitled McCulloch versus Maryland, 17 U.S. 4, 1819. If you've never heard of this case, then you're in the right place. McCulloch versus Maryland was a very important federalism case decided by the Supreme Court of the United States in 1819. This was one of the Marshall Court decisions, all of which practically were of very important constitutional significance, okay? The Marshall Court, of course, was named for Chief Justice John Marshall, who presided over the Supreme Court of the United States as Chief Justice from 1801 until his death in 1835. With respect to the Marshall Court, Chief Justice Marshall was a very proud and strong Federalist who believed in a strong central government and strong federal authority over the states when the two came into conflict. McCulloch versus Maryland was a great example of his beliefs. So what happened in this case? Well, it all started in 1816 when the Second Bank of the United States, was chartered by the Congress. And in 1818, the state of Maryland, like many other states, was getting very resentful at the Second Bank of the United States and began to tax the bank, requiring an annual payment of roughly $15,000 a year. That was a whole lot of money in 1819. It ain't bad now, but in 1819, that's a lot of bread. Now, the director of the bank, Mr. James McCulloch, refused to pay that tax, And as a result, he was sued by the state of Maryland for refusal to pay the tax, The case made its way through the Maryland courts, reaching the Court of Appeals of Maryland, which ruled that the Second Bank of the United States, the whole Bank of the United States in general, was unconstitutional. Indeed, as the Constitution of the United States spoke nothing about a national bank, where does Congress get off in creating it? Indeed, not only did the state of Maryland have the right to tax the bank, but it was unconstitutional in general, so the state of Maryland wasn't doing anything wrong here, according to the Court of Appeals. Well, it didn't end there, In appealing the matter to the Supreme Court of the United States, Petitioner McCulloch and the state of Maryland essentially presented the Supreme Court with two very simple constitutional questions. First and foremost, did Congress have the authority to create a national bank? And number two, was it constitutional for Maryland to tax the Bank of the United States? In a unanimous decision by Chief Justice John Marshall, not only did the court rule that Congress had the authority to create a national bank, but the state of Maryland was dead wrong for attempting to tax it, and that Maryland had no authority to tax an institution of the United States of America. Indeed, Marshall's opinion conceded the very obvious fact that although the Constitution did not specifically authorize the Congress to create a Bank of the United States, Congress did have the power via Article 1, Section 8, Clause 1 of the Constitution to tax and spend. I'll read that to you. Okay? Article 1, Section 8, Clause 1 of the Constitution says that the Congress shall have power to lay and collect taxes, duties, imposts, and excises. Okay? To pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. So Congress has the power to tax and spend. All right? Now, with that power to tax and spend, the Marshall Court held that a national bank was a perfectly legitimate mechanism to facilitate the intake and spending of revenues. Okay? Thus, it was perfectly legitimate to create a national bank to assist the Congress in its enumerated authority and power to tax and spend. That is essentially justified by what is known as the Necessary and Proper Clause in Article 1, Section 8, Clause 18 of the U.S. Constitution, which reads as follows: that the Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. So, the Necessary and Proper Clause, perfectly, justified the creation of a national bank as a mechanism to facilitate Congress's power to tax and spend. Thus, the bank was essentially a derivative of Congress's power to tax and spend, and therefore based upon one of Congress's enumerated powers. With that being said, the state of Maryland, these guys right here, were entirely out of line and had no justifiable authority to tax an institution of the federal government, because federal law, especially based upon one of its directly enumerated powers, federal law was supreme over state law. To allow the state of Maryland to tax an institution of the federal government would in effect render the Supremacy Clause useless. As Chief Justice Marshall said quite plainly in this opinion, the power to tax is the power to destroy. And it was absolutely unconstitutional for a state to attempt to destroy an institution of the federal government via taxation or any other way. But with respect to this case, taxation. A state cannot tax an institution of the federal government. Doing so undermines the Supremacy Clause of the Constitution, giving federal law primacy over state law. The federal government is exercising one of its enumerated powers, and state law cannot undermine that via taxation. That would flip our system over on its head, render the Supremacy Clause a pointless part of the Constitution. Chief Justice Marshall emphasized the fact, quite simply, that federal laws did not have to be absolutely necessary or proper to be in compliance with the Constitution, and that the Necessary and Proper Clause essentially, enlarged the federal government's powers, not reduce them. The Necessary and Proper Clause gave fuel and weight not only to its enumerated powers, but gave Congress the power to create things that weren't necessarily stated in the Constitution, to carry out those foregoing powers. So a bank was a perfectly legitimate way of carrying out Congress's power to tax and spend. Pardon that delay. Okay? The necessary and proper clause essentially was a provision added to ensure that Congress had the ability to carry out all of its foregoing powers, even if something that it needed to create was not specifically stated in the Constitution. Marshall's opinion includes also the famous phrase, okay, that let the end be legitimate. Let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consist with the letter and spirit of the Constitution, are constitutional. So there was no doubt in Chief Justice Marshall's mind for 1 second that the bank was constitutional, that it was a legitimate exercise of congressional power via Article 1, Section 8, Clause 1 and Article 1, Section 8, Clause 18. Okay, the power to tax and spend, and the necessary and proper clause. The bank was fully constitutional, and the state of Maryland had no right to tax it and undermine a legitimate institution of the federal government. In doing so, the state of Maryland, in being allowing the state of Maryland to do so, would essentially render the supremacy clause, giving superior deference to federal law. It would render that clause essentially pointless, as then a state would be able to actively undermine the authority of the federal government in its own constitutionally delegated area of authority. Okay? So with that in mind, the state of Maryland lost the case and was no longer permitted to tax the Second Bank of the United States. This is a very important case because it established an important boundary line between federal and state power in the early 19th century. Okay? And the 10th Amendment had no reason to be invoked here, as some have argued that Maryland had the right to tax the bank as a reserve power when it absolutely did not. Okay? The state did not possess the right to naturally tax an institution of the federal government in an area where the federal government had clear authority. That was absolutely dismissed by Marshall. Okay? So that, folks, is McCulloch versus Maryland. Okay? 17 U.S. 4, 1819. A very important federalism case. Okay? Whose essential holding remains solid to this very day. Any questions or controversies, please leave them down below, and I'll be happy to answer them. Okay? And if you don't have one by now, get yourself a copy of the Constitution. All right? And if you have not subscribed to my YouTube page, I would greatly appreciate it if you did so. Just hit that little red subscribe button, and we are in business. Take care, stay safe out there, and I'll talk to you at the next bite. Peace.